that reasoning.
But Ms. Harris,
First
can we
Amendment.
just be a little bit more specific about the Second Amendment right that you say is being infringed here? This is the point that I guess I'm still stuck on, is whether or not in a world in which we all concede, and I think the United States is on board with this, that the Second Amendment yields to the property interests of a private property owner, such that the private property owner gets to consent as to whether or not you can carry a gun on his property. When we're in that world, what Second Amendment right is being infringed when the property owner says no, or when the state says the property owner's consent has to be expressed?
So let me unpack that both in terms of the methodology and the ultimate answer. I think when you collapse the whole inquiry into a specific question of what happens vis-a-vis property rights, you're backing away from the Bruin framework. The two steps are,
well, I am backing away because the Bruin framework only applies where the Second Amendment is implicated. And what I'm suggesting is that the Second Amendment right is not being implicated when the regulation is about the property owner's consent, the form of it. Can it be implicit, or must it be express? In a world in which we've said that consent already takes precedent over the Second Amendment right.
So what we're answering here is what is the scope of the right to publicly carry under the Second Amendment, and I don't think states can get out of constitutional scrutiny by trivializing what they're doing.
But haven't you already agreed that the Second Amendment right yields to the property owner's consent?
Of course, we're not saying that you override what property owners are saying, but what we're saying is when a restriction parts ways, when it redefines the concept of trespass to essentially say for this one category of people licensed to carry, you are no longer presumptively allowed to carry at gas stations.
But you're only presumptively allowed because the presumption goes to the consent, not to your right.
I understand.
You're presumptively allowed because we're presuming that in this situation, the owner is consenting.
And this goes back to the colloquy with Justice Gorsuch, which is when states are trying to redefine property concepts, that doesn't take them out of constitutional scrutiny. Quite the contrary, in both the First Amendment context and the Takings Clause context, the rule is when the states are departing from the default in a way that implicates other constitutional rights, they can't do that. The Takings Clause may be an outer limit in sort of what exactly states can do. But it would be, I mean, just the floodgates would open if the position were all that's going on here is just tweaking how you consent. Just think about, I think in the First Amendment context, you would say, no big deal. You are now going from a world where candidates can go door to door and for campaign speech, but now you have to have a big sign in your yard that says, political speech welcome for someone to go in. Or in the Second Amendment context, Hawaii's same reasoning would lead to a rule that it's fine to ban tenants from owning guns in self-defense unless the landlord in the contract expressly consents to doing so. And I really think the concept that this is just tweaking consent elides the burden that Hawaii is imposing here of presumptively banning open carry, banning public carry.